you are injured, disabled, or even killed in the course of your work, do you know that the law provides compensation for you or your family, even if no one is at fault? Workplace injury or accident can sometimes bring about a permanent change in one's life. Unfortunately, it is surprising how many Nigerians do not know that as employees or workers of organizations or establishments, that the law protects their rights against industrial accidents, injuries, and diseases of all sorts. Many employees suffer workplace injuries every year and are left to take care of themselves alone because they do not know their rights. Hello, wonderful audience. My name is Ogochukwu Onoha, and I am your usual anchor person. So once more, welcome to a half hour with the Human Rights Wizard. On this video, I will explain the Employees Compensation Act and how you can claim your entitlements under this act, what it covers, and how you can actually go about claiming your rights or your entitlements under the act. But let us begin by asking the question, the big one. What is the Employees Compensation Act? It is a law of the National Assembly of Nigeria that provides for compensations to be paid to a worker or employee of any organization for injuries suffered, for diseases contracted, for disabilities suffered while working, or for deaths arising in the course of work. Now let us be elementary. What does this law say? It says that whether a Nigerian works in the public sector or in the private sector, or is at work or not at work at the moment, that any injury or accident suffered by such a worker, once it can be connected to his work, makes the organization liable to pay compensation to the worker. That is, when such an injury happens, whether the employer is working or not working at the moment, once the accident or injury that has happened can be traced to his work, the employer has to pay some compensation to the staff. Now, mark my words. No employer can opt out of this law. No employer can evade his or her responsibility to his or her staff, so long as this law, the Employees Compensation Act, is involved. Now let us take it bit by bit. All injuries or accidents that occur involving a worker, either from the time the worker is going to work from home or is leaving the place of work to his residence, primary or secondary residence, or to the place where he or she normally takes his or her meals, or to the place where the worker usually receives his or her remuneration, that is, his salary or pay package. Once it is verified that the injury, disease, or accident occurred in one of these places, the employer has to pay some compensation to the worker. Now, I need to clarify some of the issues I've raised here. If a worker is moving from the place of work to his place of primary residence or secondary residence, I know some of us might want to know what we mean by primary residence or secondary residence. Now, your primary residence, of course, should be the place, the first place from which you move to your place of work. Possibly, you are an urban worker or a city worker, and the place you live, the property where you live in, the yard, to use a more common expression, the yard where you live in a town, from where you go to work is your primary residence. Then, of course, you may have another residence in your hometown, your village. Definitely, there is a living space or a homestead in your village where you come from. That is your secondary residence. So an accident or injury or disease that you suffer, moving from your place of work to the place you live permanently, or to your village, an injury happening or accident happening to a worker en route to any of these destinations is an industrial accident. It's classified as industrial. It is work-related, and the employer has to pay the worker some compensation. Or the worker is moving from the place of work to a place where he or she normally has his meals or her meals, or back to the place of work, and the injury or accident occurs there. Or the worker is moving to a place where he normally receives his pay, possibly moving from his house to the bank to receive his money, or from the bank back home or to the place of work. The injury occurring in one of these places has to be compensated for. And the law says, provided the worker has duly put in writing his residence, the first residence and the second, or primary and secondary residence. And these details, of course, are usually provided during the contract of employment between the worker and the employer. In our video of episode 16, we talked about the contract of employment, how it affects you. You may need to watch that video to understand what I mean here by the contract of employment. As the law specifies, when an injury happens, the compensation for that injury begins to count the next day, and continues until the disability is taken care of or cured or corrected. Apart from that, there has to be a health care benefit paid specially to the worker for the first day, the very day on which the injury occurred. Health care benefit. After which, from the second day, the disability benefit or the disability compensation starts. Again, it may happen that there is already a disability as the worker is working. Some workers get employment suffering from visual impairment, as the worker cannot see very well, but does see, but not very well. Or is suffering from an ear infection or ear impairment that does not permit him or her to hear very well. The worker is possibly lame upon employment, or crippled upon employment. All of these are examples of disability. Some workers get to work amputated. That is, a worker had lost an arm before he got a job or before she got a job. These are disabilities that already exist. Now, if the worker falls sick and it is discovered that the sickness is related to the disability he already suffers, and that the complication resulting from that disability is as a result of the work the worker is doing, this is also classified as an industrial injury, and the employer has to pay some compensation. But in this case, the compensation is paid to the extent of the aggravation, that is, to the extent of the worsening of the disability that occurred while the employee is engaged on his or her job. That is a calculation of the amount of the illness that the worker has started suffering as a result of the work he's doing, which has aggravated or made worse the disability he or she already suffers. That amount is calculated and paid to the worker. Let us go on. Let us talk about what it covers. What does the Employee Compensation Act cover? Good. It covers workers in the public sector. If we use a more familiar expression, government workers in general. It covers injuries suffered by workers who are in the employ of the government at all levels. It also covers private sector employees, that is, workers who are in the employ of privately owned businesses. Incidentally, it is workers in this sector, privately owned businesses, that suffer the most neglect. Please watch our previous videos. You will see what I mean by this. All these issues have been thoroughly analyzed on previous videos. So it also covers injuries suffered by workers in the private sector. And then it also covers injuries suffered by contract workers or casual workers. That is, workers that are engaged for a fixed period after which the employment terminates. And it also covers apprentices, young people or older people who are learning a trade pursuant to graduating, after which they will establish their own businesses. I would like to emphasize again that your employer cannot opt out of the responsibilities imposed on him or her by the Employees Compensation Act. You see, the Act is not charity. It is a legal right. So, as an employee, you must learn how to insist on your rights being respected and on the employer performing the duties that the law has posed on him to your advantage, you the worker. Now, let's talk about the injuries and events that are covered by the Employees Compensation Act. As we do so, we will talk about some practical examples of such injuries. Let's talk about workplace accidents. Workplace accidents first. Number one, workplace accidents. Imagine that you are a forestry worker, a field worker of the government forestry department, or you work for a privately owned lumber company, and your duty is to fell trees in thick forest, in a mangrove or tropical forest. And while using the machine to fell the tree, you cut your palm or cut your wrist, or you cut one of your legs, either completely off, or you've given yourself a third-degree injury. It is an example of a workplace accident. Let us take a second example. The construction industry. You drive one of the earth movers, and a bridge is under construction, and you are lifting boulders with the earth mover. Or you have the task to demolish a story building, and in the course of work, a boulder misses its way and drops on you, either maiming you permanently or killing you instantly. It's a kind of workplace accident. Let us take another. You work in a warehouse where you constantly try to bring heavy objects down from shelves, and you wear helmets. You wear a pair of boots and hand gloves. But even at that, a heavy object drops on your head, and in spite of the helmet, it affects your neck, permanently disfiguring your neck, or drops on your arm or legs and giving you severe injuries. This is an example of a workplace accident. There are so many such examples. Imagine being a fireman working in the government fire service department, and there is a building in town on fire. So your team hurries there to help douse or quench the fire. And in the process of going there, there is a fatal accident on the road, and some of the workers die. Some sustain life-threatening injuries. Or there is no accident, but you get to the place of work where you have to quench the fire, and a member of the team gets burned severely, if not killed completely. These are all examples of workplace accidents. Now let's talk about occupational accidents, also covered by the Employee Compensation Act. Occupational diseases that result from someone's occupation. Let me give you an example. During the outbreak of contagious diseases, the outbreak of epidemics, health workers in general, nurses, doctors, and the other staff of hospitals or the other staff of health centers that come across sick people frequently get infected by the diseases they are trying to treat in their patients. During the COVID-19 pandemic, many nurses and doctors died of infections they got while trying to treat patients who were down with the diseases. It's a workplace that is occupational disease. I give you another example. Take the bank worker, for instance, the cashier. The banknotes or currency notes that we use every day for our business transactions, buying and selling, is often full of thousands of germs and bacteria, deadly bacteria that can cause us diseases. That is why it is not advisable to moisten your fingers with your saliva so as to count money. Because as you do so, the second time your finger goes onto your tongue, you will drop some germs or bacteria that you have picked from the notes. Now, even when this is not the case, when you do not have to moisten your finger to count your banknotes, just handling the banknotes alone is enough. So bank cashiers very often wear face masks to cover their noses and mouth while counting money. But even at that, many of them get infected by viruses and bacteria and germs that come from the money they handle every day. This is a kind of occupational disease. Thirdly, imagine that you work with the sewage disposal department of your state sanitation agency, and you are in the team that goes to residences to empty their feed-up, soak-away pits. This is potentially hazardous. These workers can easily be infected by germs from the decomposing sewage. It's an example of an occupational disease. The third category are injuries suffered during official duties. There are so many such injuries. The driver, a chauffeur, opens the door for his boss, and while trying to close it, the car door catches his finger. It is an injury suffered during official hours. You want to climb the staircase or go down the staircase from or to your office, and you slip and break an ankle, or break your neck, or break your waist. It is an injury suffered during official hours. So it is an example of an occupational injury or injury suffered during official hours. Then, of course, death, the fourth category, death in the course of employment. If a worker dies in the course of doing his work, in the course of being employed, we are not saying the worker dies in the place of work, no. The worker suffers illness while still in employment and dies. The employer is expected to pay the family or the next of kin of the worker some compensation. And we keep emphasizing, no employer can evade this responsibility. I'd like to give you an example. An example that I personally experienced at a place where I worked. A worker suffered partial stroke, and was bedridden for a couple of months. The employer visited the hospital and made arrangements to pay the bill, to contribute to the payment of the bill. He didn't pay everything. Then the worker resumed. One half of his body completely paralyzed. He manages to work by limping and continued to work. And the employer never made any other contribution to his good health. A large part of his monthly salaries went into securing physiotherapy treatment. And the worst was that on occasions, when he failed to report to work early enough because he had to go to a hospital for a medical checkup, or missed work completely because of crisis related to his ill health, there was an occasion where the employer had to deduct 26,000 naira from his monthly salary, which at that time was around 70,000 naira. And he told me about it weeping. He told me, the person I'm talking about was a young man, he hadn't got married. He told me his problem was to find a young woman who could marry him in that condition. A working class young woman who could marry him and help provide for him and help in his treatment, so that he will be able to change employment from that cruel employer and be able to get an alternative and better job. I sympathized with him, but I was handicapped. There was nothing I could do. Of course, after the young man discussed this with me, he didn't survive that year. When he had another major crisis, he died. That was that. There was another worker in the same establishment. He was the gate man, and he had a cancerous tumor growing, protruding close to his ears. It was small when he gained that employment, and by the time I left the establishment, some 8 years later, the tumor had grown so big that it drew all the flesh on his face, stretching them so that the skin of his face was quite tight. It was when he fell sick and couldn't continue the work and had to be hospitalized that the employer intervened, but it was already too late. I was aware that while the man was still active, they had approached the employer a number of times asking for assistance to go to hospital so that the tumor could be operated on and removed. But the employer kept telling him that he would do so when he was ready financially. And you know what? There was money in the establishment, but the employer was simply a wicked soul. So when he eventually intervened, the man did not survive the operation. He died. I am sure you know some other cases as pathetic as the ones that I have narrated here. Workers do not have to wait until they die to fight for their rights. You only need to know that a disease you are suffering while you are working is related to your work. So long as you still carry that disease and perform your duties, it is a part of the responsibility of your employer to help give you treatment. The Employees Compensation Act provides for this, because it is the toiling from the labor of workers that earn income, that earn money for the establishment. So the primary duty of an employer is to make sure that his workers or her workers are comfortable materially and medically, that's health-wise. The money that workers earn for an establishment should go first of all into taking care of the welfare of workers before any other priority. Now let's talk about what benefits. Let's talk about what benefits an employee or his family can receive through the Employees Compensation Act. The first, of course, is medical treatment. The employer has to provide for the medical treatment of the workers. Then the second is temporary disability compensation. This happens if the employer keeps paying to compensate the worker who has suffered injury until the point where the disability caused by the injury can be managed by the worker while continuing his or her job. The third is permanent disability compensation. Permanent, in the sense that the disability is such that the employer has to continue to pay compensation to help the worker cope so long as the worker continues to work in the establishment. Then, fourthly and lastly, death benefits for dependents. If the worker eventually dies as a result of the injury or disability, then death benefits is paid for the dependents. The dependents are the next of kin. That's the family, the survivors of the worker who is dead. So death benefits has to be paid to them. At this point, we talk about how to make your claim, how to claim compensation under the Employees Compensation Act, how to claim your compensation. First of all, the injury or accident occurs. The injury or accident has occurred. We imagine it has occurred. What happens? The employer reports to the NSITF, that is National Security Insurance Trust Fund. That is the federal government agency that has the funds with which workers are to be compensated. That is who to report to. And then this agency collaborates with your employer to make sure that the compensation due to the worker is paid. Then, if this has been done, then the third is medical assessment. The NSITF assesses the condition medically, find out what it would take to treat the worker and rehabilitate the worker. After that, a determination of benefit is done. A calculation of the benefit accruable to the worker is done. After that, the fifth step is that the payment of compensation is done. As an employee, you have to insist on reporting to NSITF. You have to insist. The employer may sometimes be reluctant because they do not want to spend. But you are the one directly affected, so you have to take it upon yourself to get the employer to report to the right agency. And if the employer does not do this, you can take the report to NSITF yourself. If you have been following our discussion and you have learned something or you have enjoyed our session today, what should you do? Like and share this video. It is important that you help us to make this video have as wide a reach as possible. Get others to know about this video and this channel. Then subscribe to this channel so that you get our video first hand each time we publish a new video. Before we conclude, let's talk about common misconceptions or myths associated with the Employees Compensation Act. Number one, you must sue your employer. That is a myth. No, you don't need to sue your employer to get your compensation. You only need to report to the NSITF, which I've mentioned. Report to this agency. If your employer refuses to pay your compensation, it is that agency that will sue your employer to court if litigation, that is, if a lawsuit becomes necessary. Second misconception, only permanent staff qualify. No. Anybody working in an establishment, even if the establishment comprises just the employer and one employee alone, like I enumerated earlier on, public sector workers, private sector workers, contract or casual workers, and apprentices are all qualified to benefit from the Employees Compensation Act. And lastly, number three, it applies to factory workers only. No, this is rubbish. A worker is a worker, whether the person works in a factory, works in an office, works on the top of a building, works underground. They are all workers. So they are all qualified to benefit from the Employees Compensation Act. As we close today, I will adjure you, I will implore you once more to be law-abiding. That is the whole aim of this channel. If you respect other people's rights, they will respect yours. Or you would deserve to have your own rights respected. And do not forget our slogan. Know your rights, protect your rights, and defend your rights. I invite you to join me on our next video. Until that time, take care of yourself and stay away from trouble. Bye-bye.